Welcome to Time to Get Your blah, blah, blah together. We will be discussing everything from estate planning to how to avoid a probate administration and everything in between. Let me introduce to you Samantha Fitzgerald, who really needs no introduction. Samantha is an attorney in plantation, and her firm is 100% focused in estate planning, probate, and trust administration. She's been practicing for over 20 years, hard to believe. She's a CPA and she has her LLM in tax. My name is Bianca Moreras, and I will be your host and moderator for today. I am a business development and career transition consultant. I bring over 36 years of experience to the table, and I concentrate in law firms and helping attorneys attain what they think is not attainable. So without further ado, today we are going to be focusing on disinheritance. Very exciting. All right. Good morning, Samantha.
Good morning, Bianca. Thank you for the intro. Hi, everybody. Thank you for joining us. This is fun. This is, a fairly informal event. It's going to be short and sweet. And as Bianca said, we'll have time for questions after, or you can put them in the chat box along the way. And you're always free to contact me at any time afterwards as well if you have additional questions.
Awesome. So we have another guest. So we're going to get started here. Hello, Kanye. Thank you for joining us. This is actually a very good friend of mine, Sam.
Oh, nice. Welcome. Thanks for joining us. This is awesome.
So let's get started. I have a question here. Can I disinherit my child?
Absolutely. So children have no preferential rights. They have no right to an inheritance. If you don't have estate planning documents, then, they're on a list of people that are going to inherit at some point. But they have no right to anything. So you absolutely can leave them out of your estate. You can leave certain children out of your estate and give part of your estate to other children, so it doesn't have to be all or nothing. You are really free to do whatever you want when it comes to your children.
Well, does that include stepchildren, Samantha?
Even better if you're looking to disinherit somebody. So stepchildren have no rights at all. Adopted children are different. So if you've legally adopted somebody, they are your actual child. Although there are some funny rules about that. It may or may not disinherit them from their biological family, which is interesting. But for your purposes, if you've adopted a child, they are your child for legal and estate planning purposes. So you don't have to do anything special for them. They're your child. Your stepchildren, on the other hand, are nothing to you legally. So sometimes this works in reverse, where people have raised a child for their entire life and they view them as their children and they want to leave them something. So it's especially important that they actually have documents and leave them something in those documents, whether it's a will, a trust, or both. I had that happen one time. I had a client and her existing documents, she came to me to make changes. Her existing documents referred to these people as her children, but they were not. So oftentimes we'll use the term descendant or something along those lines. Your heirs, your descendants, your issue is a kind of an older term. And that means your children, your grandchildren, your great-grandchildren. Had I done that and we didn't have a conversation, we would have disinherited her stepchildren, who were basically like her children. She raised them their entire life. They were her children. So it's really important that, you have a conversation, that this information so that to bring it up if your attorney doesn't ask, or if it just doesn't come up in regular conversation. But if you don't want to leave anything to your stepchildren, you absolutely don't have to. But if you do want to leave them something, then it's really important that you make the appropriate arrangements for them. Now, I will say though, if you don't have any documents, your estate passes by way of what we call intestate, meaning it passes according to Florida law, and it goes to certain people in a certain order. It actually would make it all the way over to your stepchildren if you had no other direct heirs, so no parents, no grandparents, no aunts, no uncles, no cousins, no children, no spouse. If you literally have nobody, then Florida law says your estate will pass to the heirs of your deceased spouse. So if you were married to somebody at the time of their death, so your spouse predeceased you and you never remarried, and they have some sort of heirs, which could be their children, then your estate may pass over to them, whether you want it to or not, if you don't have documents and you have no other heirs.
Wow.
Hopefully
Better
that
get
wasn't
those
spooky.
documents written. Oh my gosh.
Yeah.
Oh, look. And here's the, $1,000,000 question. Can I disinherit my spouse?
Well, I can see what side it's on. My spouse punched me in the eye yesterday, so I am going to disinherit him. Now, I think I have a sty, everybody, but it looks worse on Zoom than it really looks in real life. So disinheriting a spouse is a lot harder. So in general, you can't completely disinherit your spouse unless your spouse agrees to that. So once you get married, your spouse is entitled to certain things automatically. You could be married for 1 minute and they are automatically entitled to certain things. Death of a spouse is very different from divorce under Florida law and probably under every state law. So some of the big things that spouses are entitled to, they have rights to your homestead, your primary residence. They have what's called an elective share. And I'll explain these a little bit more. They have maybe right to your vehicle, and something called a family allowance, which those are all smaller things. The two biggies are homestead and elective share. So elective share basically says that your spouse is entitled to 30% of every single thing that you own, regardless of how it's titled. So a revocable trust is not going to help you. Having accounts with beneficiaries listed or jointly owned with somebody else that all pass outside of probate, they're not going to help you. How else? It includes life insurance policies. Now there's some special rules, for certain things, but generally speaking, elective share means 30% of pretty much everything that you own. Which really catches people off guard. And then there's homestead. Homestead is really tricky. So the thing about elective share is that's an active election that your surviving spouse would have to make in a probate administration. So somebody first has to open up a probate administration, and then your spouse has to file something in there saying, yes, I want to take my elective share. If they don't do that, they don't get it. And then things pass the way they're going to pass. Homestead has different rules. So if you have a primary residence, it's considered your homestead. If you are married for 1 minute and you die, your spouse automatically gets a life estate in that property, meaning that they can live there for the rest of their lives, or they can rent the property out. They can kind of, sort of do whatever they want with that property for as long as they live. Or somewhat new law, I mean, it's not that new anymore, but it's still kind of new. Instead of that, they can make an election to take a 50% interest in the property. So instead of the life estate, they own half of the property, and then your children own the other half. That assumes you have children. If you don't have children, your spouse just gets everything. But there's a significance of being able to take that 50% interest as opposed to the life estate, You can force the property to be sold. But the life is, and that's something, again, like the elective share, you have to elect that. And there's a time limit for doing that. But the life estate happens automatically. So this really, really catches people off guard, because I can't tell you how many times I've had a client and they say, well, this is my second marriage, and what's mine is mine, and what's his or hers is his or hers, and we both have children from prior marriages, and this is my house. I had it before we were married, and, you know, my spouse hasn't contributed anything to it. And I say, well, Florida law says that your spouse is automatically going to get this life estate, you know, if you die. Oh, well, that's not what we want. Okay. Well, but that's what's going to happen. So trying to undo that after you've already been married can be tricky. There are ways you can do it, of course, but so disinheriting your spouse becomes very tricky. You know, just about anything is possible as long as everybody agrees, but in general, you can't just say, I leave my spouse nothing, and get away with it.
I don't know. That's a little uncomfortable, but you know, Samantha, what if I have a prenup or a postnup? Does that help?
Yes, absolutely. So you can waive all of these things in a pre or postnup. Prenuptial agreement, for anybody who's not familiar, that just is like a written agreement between the to-be husband and wife before they get married. If you don't do it before, you can do it after, and it's called a postnuptial agreement. They're much harder to get because you've already sealed the deal and you've gotten married. So now, you know, people aren't so inclined, you know, to agree to things. So it's much better to do it beforehand. But absolutely, you can waive all of these things in a written agreement. Usually they do, that's like a standard thing. They're going to discuss and touch upon death rights in any sort of, you know, prenuptial agreement. And if you do that, you can always leave your spouse something in your will or trust. That's okay. Even though the prenup says they have no rights, all it's doing is eliminating their automatic rights. But then you're free to voluntarily leave your spouse whatever you want to leave them, and it's not going to nullify the prenup or the postnuptial agreement.
Oh, well, not to beat a dead horse, but is there any way to waive spousal rights in the absence of that prenup, postnup? I think you covered it, but am I missing anything?
There sure is. There's two other ways. Your spouse can simply waive in writing the death rights. So there's a statute which allows for this. It can be as general as I waive all of my rights. It has to be in writing. It has to be witnessed. Where it gets a little tricky is you really need to disclose both parties, well, who's ever waiving their rights. And typically we're doing it on both sides, but it doesn't have to be. You have to disclose all of your assets or it's not going to be valid. So you can't ask a spouse to waive a right to something when they don't really know what they're giving up. So if you were to say, hey, you know, sign this and waive your right to my homestead, and it turns out, or waive your right to the elective share to 30%. Well, 30% of what? Turns out your spouse has $100 million over here and you didn't know you were giving that up. So you have to disclose your assets. It has to be in writing. Both parties, you know, should, in a perfect world, they're both going to be represented by separate lawyers so that they can't try to say after the fact, well, I didn't understand what I was signing, or they forced me to sign it. Unfortunately, it doesn't always work out that way because, you know, if you're doing a quick waiver of rights as opposed to a full-blown prenuptial agreement or postnuptial agreement, people don't want to hire two separate lawyers to do something because it's expensive. So oftentimes either one party is not represented or you have one lawyer that's representing both parties. And if you're both waiving your rights and you've both disclosed your assets, you know, then hopefully everybody's on the same page and there's not going to be a problem. But if the lawyer is only doing planning for the one spouse, the other spouse really, at a minimum, should be advised that they should have their own separate counsel. And even better, if they can hire somebody to represent them through that process, that would be better. But you can waive your right in just a document that doesn't touch upon any of the divorce stuff. So it's not going to touch upon alimony or child support or any of that stuff. It's just going to deal with the death rights. In addition, another fairly new rule is you can waive your right to homestead in a deed. So that is really kind of cool. Your spouse has to sign off on a deed anyway. So as long as, again, they're getting the proper guidance, they can waive their right to the homestead in the deed itself, which is a handy kind of new rule that we have.
That sounds much more simple. But we do have a question here, and I think it's very poignant. Someone is asking, what if I'm the one that's disinherited? And do you have any recourse?
Perhaps. So it really depends. Sadly, a lot of these types of cases end up settling. So somebody that was intended to be disinherited may end up with something because, looking at it as a business decision, it's cheaper to settle with somebody than to litigate in court because you have to pay lawyers. And it drags on for a long time, and your asset may be losing value while you're fighting over it. So generally speaking, unless there's a reason to invalidate somebody's documents, they should be allowed to disinherit whoever they want. So if there's a disgruntled child or grandchild or girlfriend, the deceased is allowed to disinherit whoever they want unless they have some sort of right, like a spouse. However, there are lots of other variables that are often involved, such as, was there any coercion? Was there any duress? Did the testator, the person who made the documents, did they have the requisite mental capacity to understand what they were doing and to sign these documents? That's probably one of the most common methods of attacking documents is that, and oftentimes it's mom or dad, they weren't competent anymore, to be signing documents. They didn't understand what was going on, or there was some sort of coercion. There was a caretaker or a child, that put documents in front of them or brought them to the lawyer. So if you've been disinherited, you certainly want to speak to a lawyer and discuss the case and see what your chances might be, because there's a lot of people do bad things out there, and they take advantage of usually elderly people or sick people, and it's a shame. So there's lots of litigation on this topic. You may have recourse and you may not have recourse. Just because you're somebody's child or grandchild doesn't automatically entitle you to a piece of the pie. They are allowed to disinherit you. So it depends, but you should talk to a lawyer. Usually these cases are taken on a contingency basis, not always, but usually. So you may not, if you have a decent case and somebody wants to take it, you may not have to come out of pocket unless there's a recovery.
Good to know. Wow. Well, I heard way back when that it's best to leave someone you're disinheriting $1. Is that true?
Absolutely not. So leaving them anything in your documents makes them a beneficiary. Now they're entitled to all sorts of things. They're entitled to notices. They're entitled to copies of documents. It doesn't matter if it's $1 or $1 million. There's no such rule which says, oh, if I'm leaving them $1, that means that, they're not, that I intended to leave them nothing. No such thing. If you intend to leave them nothing, leave them nothing, and say that. Be clear in your document. It's always good to do that so nobody can ever claim, oh, they forgot me. It's a typo. The lawyer, is a drafting error. No, You clearly say, I have disinherited Joe Smith, and you can give reasons if you want, but you don't have to. It was intentional, and that's it. Sometimes we have difficult beneficiaries, and another way kind of around that, if somebody wants to leave them something, but they don't really want them involved in the process, we'll discuss some options, but one option I often tell clients is to put some money in an account if you have the liquidity to do that, and name that person as a beneficiary on that account. That account goes directly to that, let's say it's a difficult child, that account goes directly to that child, and that's it. They get something, so you didn't have to completely disinherit them, but they're not part of your overall estate administration process.
That is very good to know. Thank you for clearing that up. Now, if I disinherit someone, are they entitled to copies of my will or my trust?
No, only if you end up in litigation where they are doing discovery, but in general, no. Beneficiaries are, and that's why we don't want to leave them $1, because theoretically then they are entitled to your will and your trust. But if you've left them out and they're not named, they're not legally entitled to anything.
All right. And what's the best way to ensure that my wishes are followed?
Documents. Absolutely have your estate planning documents prepared. Everybody should have a will. Most people should have a trust. We've covered in prior Zoominars, a will only controls the probate process. That's it. It has no other effect on anything. One of your goals should be to keep your estate out of probate. That's where the trust comes into play. A trust is privately administered. There's no court involved. It's much more private. A will is a public record document. Anybody can get a copy of your will because it's filed with the court system. If you have difficult beneficiaries or difficult people out there that you think are going to cause trouble, you absolutely want to keep your estate out of probate and keep it private. It makes it that much more difficult for this person to cause trouble. I can pull up anybody's will right now online. I can log into the court system and pull up anybody's will and see, who the beneficiaries are in a case. But absolutely, if you want some specific person to inherit or disinherit your estate, you absolutely need to get your documents in place. Excuse me, not only for death purposes, but if you have somebody specific that you want to be making medical decisions for you or financial decisions for you while you're alive, you need to get your documents in place. You need healthcare surrogate designations. You need durable powers of attorney. These documents are so, so, so important for everybody, but especially for those people who have any sort of difficulties in their life with their children or whomever. I administered a estate recently. This person died. They were not old. They were in their 50s. They passed away somewhat unexpectedly. No spouse, no children. So who are his beneficiaries? His parents. Those are his heirs. Well, he was raised by his biological mother and his stepdad his entire life. His biological dad was a deadbeat dad. So his stepdad was his dad for all intents and purposes, but not the law. So we had to find his biological dad, and he ended up getting half of his estate. And man, can I tell you, his stepdad was mad. He was mad that he raised this boy and his two brothers. And his dad, who had nothing to do with any of them their entire lives, was getting half of his estate. But he had no documents. There's nothing you can do in that case. And things like that happen all the time. There's just nothing you can do except be prepared.
Right. So it's like the motto of the day is be prepared.
Be prepared.
And, I want to open it up now for questions because, boy, there's a lot of curiosity, I'm sure, going on out there. I know Danielle has to have a question. She's been taking such diligent notes.
I take diligent notes because I have like a 2-minute memory. So I'm one of those people that always goes back on my notes because I just forget. No, I think this was very, very, very good. So thank you. And I will type these notes up. No, I think it's very helpful. And the takeaway is just have your estate in order. Just make it known what you want. And there's no replacement for that, huh?
No, and the time to do it is when you're young and healthy. Because when you're sick or getting older, that's not the time to do it. You know, you don't want to be scrambling to get documents in place. You can always redo them. You can always modify them. So what are you waiting for? You have to have documents in place when you're young and healthy. And of course, every few years, you should look at them and think if you need to make any changes to them. But anything can happen. I mean, I administer estates for people in their 20s up to people in their, 100 and everything in between. We all know that anything can happen. People die. People die in car accidents. People die in weird accidents. People die from health-related issues. There's all sorts of things that can happen. You don't expect it, but it happens. But it's the reason why we do these documents, because of the unexpected. So I can assure you, you do not want to be scrambling before a vacation or before surgery or after you're already sick. The worst calls I get are when people call me trying to do something for somebody or to get documents prepared and the person is already incapacitated. And I have to tell them, I'm sorry, I can't help you.
Yeah, very sad. Yeah, health is the biggest issue for sure. Do we have any questions from the audience? You can either chime in, or if you want to stay confidential, you can put it in the chat. Hi, Terry.
Hi.
Hello. Josh, be quiet. If I have a son whose values are all of a sudden deviating from my own, and I choose not to honor the original will that I have in place, would you recommend having a discussion with him?
It depends what you want to do and what your documents say. So like if you're talking about, if you just don't like his behavior and you want him to change it, then yeah, sure, it really depends. That's a very specific question. It's always good to have a conversation with somebody if you feel comfortable doing that. But you also have to make sure that your documents reflect what you want to have happen, because you can't control other people's behavior. And what's really sad is when somebody intends to make a change and then something happens to them and they don't get around to it. And then their current wishes when they die are not reflected. And just like the case where you don't have any documents and your deadbeat dad is going to inherit half your estate, we can only go by your documents in effect at the time of your death. So I see very often it happens where somebody was in the middle of updating their documents, and unsigned documents don't exist. They are not documents. They have to be actually executed. It doesn't matter how far along in the process you are, it goes by the documents you have in place. So, certainly have a discussion with them. But if you're talking about like, I'm going to disinherit them and I'm going to have a discussion and tell them why, that's good too. You can also leave a written explanation of why you're doing it. So you don't necessarily have to have a big long explanation in your will or trust, but you can leave like a letter of intent, we call them, explaining why you did what you did or why you changed your documents. That's really, really helpful, because that's contemporaneous with the change in documents and it goes to your intent. And the settler's intent is paramount. I mean, that's what is always tried to be followed, but you're gone when somebody's administering these documents. So you can only go by, the evidence that's out there, your documents, testimony, your actions. So if you put in writing in a letter why you've excluded somebody or disinherited somebody, or why you've made changes, or why you've left more to somebody, or what you want to have happen with XYZ, that is super helpful.
Any
Thank
other
you.
questions? I hope we answered your
I hope so.
question, Terry.
Yep, thank you.
Good, good. I do have a question. What if you have a child that has special needs and they're one of 3 in your family? What type of document would you suggest to make sure that that third child, let's call it the third child, can benefit but not go crazy, with the inheritance because they don't have the wherewithal?
Yeah, well, you definitely need a trust in place for sure. Somebody else needs to be the trustee, so that person would be in charge of, dishing out the money to them. And if they're actually disabled, maybe they're receiving, Medicaid or SSI or something like that, you need a special needs trust, also called a supplemental needs trust, which is a special type of trust that will allow them to not be disqualified from receiving the need-based government benefits, but it will be held in trust. So in my documents, I put in a special needs trust in every single trust, just in case. It's there as a contingency plan, just in because somebody may be fine today, but when you die, somebody may be disabled. And it may not be a huge disability, but it may be something that they qualified for SSI or Medicaid, and those are need-based programs. And a regular trust is treated as a resource to them. Even though they don't have full access to the money, it's theirs and it's treated as a resource. So they would lose their benefits technically. So it needs to go into a special needs trust. But absolutely a trust. If they're not receiving any sort of need-based benefits, then maybe just a regular trust would do. But you definitely want to hold something in trust and put somebody else in charge of the funds.
Good information, good information. So if there aren't any other questions, I just want everyone to know that Samantha is always available by phone, Zoom, to give you, answer any of your questions, even after this broadcast. And if you do not have your documents in place, or you're thinking about making a change, please don't hesitate to call the office. They're the friendliest, most loveliest, competent and professional people that I've come across. I want to thank you all for coming. And remember, we're here the third Friday of every month at noon. Please invite your friends and family and those that you may come into conversation with. This is an educational only program. So everything here is what I'll call holy ground. You can ask your questions and you don't have to worry about, anything other than getting some good, valid information. Samantha, I thank you. Have any last
Thank you,
words?
Bianca. Nope, thank you very much. I appreciate it. Thanks everybody for coming. This is great. And please join us next month. We have a different topic every month.